The hearing on this application is being held by way of video conference with Justice Sir Jeremy Cooke, the judge hearing this application is appearing from the UK. Any orders or directions made after or during the course of this application will be issued by the registry in Dubai on Justice Sir Jeremy Cooke's instructions. We are here for a hearing in the matter of CFI-059-2020 before Justice Sir Jeremy Cooke. The claimant is represented by Abdul Hakim bin Hirz Advocates and Legal Consultants. Lead counsel is Mashoud Iqbal. The defendants are represented by Al Tamimi Company. Lead counsel is Patrick Dillon Malone.
Very good. Mr. Iqbal, it's your application.
Good morning.
Why don't you begin? Thank you very much.
Good morning, my lord. Just for the sake of housekeeping, only to confirm that those instructing me have prepared a case management bundle, quite a voluminous bundle. Just wanting to confirm whether your lordship has this bundle in a paper copy format or an electronic format.
I have 518 pages in electronic format.
I'm grateful. Bearing in mind, although the speed of technology, but the impediments, I would therefore try to go as slow as possible so that we can all cross-reference to different pages, bearing in mind that we have electronic bundles.
Yes, that would be very helpful. And the numbering doesn't quite fit with the index as far as I can see, but at all events, I can find things as necessary, I'm sure.
I'm grateful, my lord. Now, this is an application whereby the claimant is seeking to have certain parts of the defense struck out in the alternative of summary judgment in relation to some parts of the pleaded claim.
Yes, you can take it that I've read the papers, I've read the skeletons, I'm familiar with the general outline. Thank you. So you can move straight to the submissions.
Grateful, my lord. May I please go straight to page number 101 in the bundle. The numbering that I'm referring to is at the bottom right-hand corner of each page.
Right. Okay.
And that is where we have a document headed as legally binding heads of agreement, the agreement.
Yes, very good.
My lord, this is the document that I have referred to as Sunset RAG heads of agreement, and it is the termination of this contract by the defendants that is the subject of the dispute in this claim.
Yes.
The first page of this contract refers to the two parties, Fixed Sense Management, the claimant, and Sunset Hospitality Holdings, the first defendant. My lord, then towards the end of the page, there are a number of services which Fixed Sense are supposed to provide. The most important of those services is at little a, which is that Fixed Sense shall be a shareholder for the registration of 51% of the shares in Sunset Group companies in the name of a UAE national or a corporate entity wholly owned by UAE nationals, in order to ensure that the relevant Sunset Group company comply with the requirements of the UAE CCL. Now here, there is a reference to Sunset Group companies. Just making a very quick reference, the two Sunset Group companies which we shall be referring to time and again is number one, Black Tap, and number two, Brick Oven. Just for the purposes of taking a quick note, the relevant documents, the Memorandum of Association for Black Tap, can be seen at page number 57.
Yeah.
And brick oven can be seen at page number 87.
Yeah.
My lord, if I may make a quick reference, first of all, to page number 57, that is where we can see Black Tap Memorandum of Association.
Yes.
My lord, as we can see in the middle of the page, that there are two parties. Number one is Hannah Habib Mansour Habib Al-Hers, who is the director and the 99% shareholder of Fixed Sense Limited, LLC. And number two, the second party is Sunset Hospitality Holdings Limited, the first defendant.
Yes.
My lord, then in this document, if I can please make a reference to page number 62, please.
Yes.
Just in the middle of the page, we can see that there is a division of the shareholdings. It says first party holds 102 shares. The total shares are 200. So 102 are for Miss Al-Hers, who's the first party, and the remaining 98 shares are for Sunset Holdings Limited. My lord, if I can then move to page number 64, please.
Yes.
It's the clause 7.8 of the Memorandum of Association. I shall simply leave that for your honour, for your lordship to read through that, which simply requires that not less than 51% shareholdings has to be in the name of a UAE national.
Yes.
My lord, then if I can please go to page number 66, please. That's clause 9.1. (9.1) refers to management of the company, and therein we can see the column that reflects the English translation, that the general manager of the company is Antonio Gonzalez Ortuno, who is one of the shareholders of the first defendant.
Yes.
My lord, then I am in fact reluctant to take your lordship through to the every paragraphs. However, clauses 9.2 onwards, it reflects number of activities that the general manager is to perform on behalf of Black Tap.
Yeah.
Now, I would make a quick comment by submitting this, that the number of activities that we can see in clauses 9.2 onwards that are to be performed by the general manager, we can see more or less the same services if we come back to page 101, that is the heads of agreement. I shall wait until you should get to that document. Okay.
Yes.
And in that, again, at the bottom of 101, where we can see the services, service number A, I've already taken your lordship through that. The services section travels to the next page at 102.
Yes.
So there we can see that services B, C, and D, these are the services which we say can be performed by the general manager, but nevertheless, Ms. Al-Hers had been performing these services because, as per little a, since she was holding 51% shareholding and being a majority shareholder, she was performing the other services too, but the general manager could also perform those. So the point I'm seeking to make is that the most important service that Ms. Al-Hers was to provide was to hold 51% shareholdings, and that is entirely in line with clause 7.8 of the Memorandum of Association of Black Tap. My Lord, again, very briefly, if I can make now a reference to page number 87, please. That is where we can see Brick Oven Memorandum of Association.
Yeah.
There again, we can see that the first party is Mrs. Hannah Habib Mansour Habib Al-Hers, and the second party is Messrs. Bichura FZ-LLC. On page 89, we can again see the division of the shareholding that is entirely consistent with Black Tap, i.e. 102 shares for Ms. Al-Hers and the remaining 98 shares for Bichura. And turning on to page number 90, we have clause 6.
Yes.
And we say that again, like Black Tap, it refers to the 51% shareholding. And on page 91, Article 9, the management of the company, and again we can see the name of Mr. Antonio Gonzalez Orchuno, and then the number of services that he was to perform. So the submission is that the basis on which Black Tap stands are the same basis on which Brick Oven stand. Now, once again, my lord, I'm coming back to the heads of agreement at page number 2 to make the point because of which I have taken your lordship through to these documents. And it's page 102, please.
Yes.
My lord, here, towards the bottom of the page, we can see a heading on the left-hand column, effective date.
Yeah.
The effective date of this agreement shall be 1st of July 2016, and this is where I put my emphasis, and I have underlined this section. It shall remain in force for an unlimited period.
Well,
So
I understand all that, Mr. Iqbal, but what about the nominee agreements themselves, which are said to prevail over the Memorandum of Association?
That is indeed taking me to my very next point, and I'm just going to go to the nominee agreement. The first nominee agreement we can see, well, before I actually go to that, the very next paragraph at page 102 is the fixed fees, which is about £40,000 per annum.
Yes.
That is
Yes.
to be revised each year. The
Yes.
next section about anticipated fee agreement, we say that there is no dispute in relation to anticipated fee agreement, and that has now come to an end. However, now, as your lordship referred to the nominee agreement, there are two nominee agreements. The first one is Black Tap nominee agreement. We can see that at page number 126.
Yes.
This is dated 18th of December 2016 between Black Tap, Ms. Al-Hers, and Sunset Hospitality. Now, therein, at page number 127, the next page, we can see consideration. It reflects £10,000, 10,000 AED. However, I'll come to this consideration just a moment later, but before I do that, if I can please make a reference to clause 5.5, that is at page 128, please.
Yes.
So that clause, well, I think I will leave that to your lordship to read through that. And taking this opportunity, if I can make a similar point by now referring to Brick Oven NA at page 132, that is the second nominee agreement.
Yes.
It's dated 25th of May 2017. Page 134, consideration is 72,000 AED. And we can see at page 135 the similar clause 5.5 as we can see in Black Tap NA nominee agreement. So clause 5.5 is identical between the two nominee agreements.
Yes.
So my lord, my first point is this, that when clause 5.5 requires Ms. Elhers to transfer the nominee shares to any person to the order of Sunset Holdings for Black Tap and to the order of Petura for Brick Oven.
Yes.
However, if we go back to the heads of agreement at page 102, that agreement requires Ms. Elhers to hold 51% shares in those two companies, Black Tap and Brick Oven, whereas Brick Oven and Black Tap, clauses 5.5, require her to transfer the same shares.
Yes.
So the submission is that if she performs according to clauses 5.5 and give away the 51% shareholding, then that would bring an end to the mother agreement, which is the heads of agreement, Sunset Rag heads of agreement, because that requires her to hold 51% shares, and if she doesn't do that, then there's no point in her remaining in that agreement. So what we say is what the mother agreement, the heads of agreement, gives by right hand, the two nominee agreements take it away with left hand. And if, my lord, I can once again, with respect, refer back to the heads of agreement at page number 104, please.
Yes.
And that is where on the top we can see the cross default clause, which is the centerpiece of this application and this interpretation. So what we actually say, that this cross default clause requires Ms. Elhers to abide by any other agreements, and if the other agreements of Black Tap and Brick Oven are valid agreements, then the effect of those agreements will be to bring the Sunset Rag heads of agreement, the mother agreement, to an end. So either way, if Ms. Elhers performs in accordance with clauses 5.5, the heads of agreement has to come to an end. If she doesn't perform in accordance with the two nominee agreements, in that event, the cross default clause will trigger, bringing the mother agreement to an end. And we say that the defendant, the first defendant, specifically designed the scheme so that and effective and could be brought to the mother agreement, because the mother agreement says that it shall remain in force for an unlimited period. Before I leave this point, there is one particular email that I would make a quick reference to, with apologies, my lord. My lord, if I can make a quick reference to, well, this is page number 334, and it's numbered at the bottom middle of the page.
334.
334, my lord, yes. It is a copy of an email dated 30th of July 2019.
Hold on, I'm not there yet.
Okay.
Well, bear with me, I'm not there yet.
Right. It's in section F18, F18.
Sorry, I've gone way past it. 334. No. Organised in a strange way, these papers, but sorry, it's section F, did you say?
My lord, yes.
All right, I'll go that way. And I'm looking for what date?
An email dated 30th of July 2019 that can be seen in the middle of the page.
Okay. I'm nearly there. I always find having electronic bundles takes twice as long as having a hard copy.
My lord, I share the experience. I also find the same difficulty. That is the reason that I'm trying to go slower than I would normally do in an open court with hard copy bundles.
Yes, well, please continue. Anyway, I've got there. 334. 30th July, dear Antonio, from Mrs. Alhurst.
That is indeed. And it's the paragraph number 2 of that. I would simply leave that, first of all, for your lordship to read through that, and then I shall make a quick comment on that.
Yes, well, I've read this one before. Yeah, I've got it. Yeah.
I'm grateful. So that, in fact, reflects that the relationship between Ms. Alhurst and the defendants started becoming sour, and Ms. Alhurst reflected a concern that, in her view, she was going to be replaced by somebody else to undertake the services that she was performing. And we say that clause 5.5 facilitate the defendants to replace or to say a goodbye to Mrs. Alhurst once and for all out of the mother agreement, the heads of agreement, and obviously black tap and brick oven. So we say, first of all, the defendant's reliance on the cross-default clause, which we say is a suicidal clause for the heads of agreement, the mother agreement, is unconscionable because it either way, it puts Mrs. Elhers in a catch-22 situation. If she if she complies with 5.5, mother agreement comes to an end. If she doesn't, even then the mother agreement comes to an end. That takes me to my next point, which in my skeleton arguments...
Can I stop you there and ask a question?
My lord, yes.
The heads of agreement, which is plainly, as you say, the starting point, so to speak, in terms of looking at the services that are going to be provided, the fixed sense services as set out towards the bottom of page 125, as you have it, I think.
Yes, my lord.
Provide the services primarily to Sunset RAK and only subsidiarily, so to speak, if the parties agree, to various subsidiaries and affiliates, which are referred to and defined as the Sunset Group. So to say that the heads of agreement comes to an end simply with reference to the two subsidiaries isn't right, is it? There's room for services still to be rendered to other subsidiaries, should there be any, or even to Sunset RAK itself, unless this is terminated under the cost default clause.
My lord, there are 4 connected entities in this dispute. First being Sunset RAK, second being Sunset Group, that is the mother company of Sunset RAK.
Well, it isn't, is it?
Well, because Sunset BVI holds...
Sunset Group is defined as the subsidiaries and affiliates of Sunset RAK.
No, my lord, I would take to another document. That's not right, because Sunset Hospitality Group Holdings Limited owns Sunset RAK. So the second defendant owns the first defendant.
I understand that.
Yes. And then it's Brick Oven and Black Tap. Those are the 2 subsidiaries in question. There is no third or fourth or any other subsidiary that is in contention. So it's only those 2 subsidiaries. However,
I understand that, but all I'm saying is that there's room under the fixed sense services clause for other entities to exist, isn't there?
There is a room in theory, but in actual dispute there isn't any in existence.
Understood.
Yes. My lord, unless I can be of any assistance to you on this particular point, I intend to move on to my next point.
Yes, please do.
I'm grateful. Thank you. Now, my lord, so that I can make best use of my time and remain focused and concise, this time, if I can please make a reference to my skeleton argument, that is dated 29th of December 2020. I will see where in the bundle we can find that. That is... It's page number 335, my lord. Section G1.
This is your supplementary skeleton, yeah.
I'm grateful, my lord. Yes, that is indeed the one. My lord, it's paragraph number 13.
Yes.
And the whole point that we are trying to make there is that the UAE federal law requires Mrs. Al-Hurst to hold 51% shareholding in the company. I am reluctant to read through everything that I have already written in my skeleton arguments, particularly from paragraphs number 13 until paragraph number 19.
Yes.
Insofar as paragraph number 17 is concerned, my lord, there I have referred to an extract from an email dated 23rd of May 2016 from Mr. Gonzalez to Ms. Al-Hurst. That, again, for the sake of completeness, can be seen at page number 139 in the bundle. Sorry, just get to that. That's, yes, 139, section B 139. Yes, page 139 reflects the email in which we say that the first defendant was aware that the nominee agreements, particularly clause 5.5, which require Ms. Al-Hurst to give away the 51% shareholding, may not be enforceable. The respondents' broad brush reply to that is that no, it doesn't. And to demonstrate that, if I can make a reference again to this time to page 354 in the bundle at section H1, my lord.
Sorry, page again. 354.
354, my lord. Section H1.
Yeah, what am I looking at? Page 354?
My lord, this is, well, first of all, on the top right-hand corner, it's a different claim, CFI-024. That's a claim brought by the defendants against Miss Al-Hurst in person, and thereby they are seeking specific performance in relation to the two nominee agreements.
Yes.
Miss Al-Hurst filed a defense, and in reply to the defense, this is the document that we can see from the defendants in this claim and claimants in that claim.
Yes.
Now, it's paragraph 5 of this document. It is denied that the nominee agreements were procured by misrepresentation and/or that they are contrary to the public policy of the UAE. That's the defendant's position in that. And if you turn to the next page, if you turn to paragraph number 27, please. And this time again, with reference to paragraphs 28 and 45, it is denied that the Black Tap NA and Brickoven NA, or either of them, are unenforceable and/or are contrary to public policy of the UAE.
Yes.
If we then go to paragraph 29, the same point is made in paragraph 29.
Yeah.
And also the same point is made in paragraph 38.
Yes.
And we say that that amounts to a bare assertion. Not even a word is offered in support of this contention. So the defendant's position simply amounts to a bare denial, without any reasons, that the nominee agreement, particularly clause 5.5, is contrary to the federal law of the UAE. And lastly, before I leave this point as well, if we were to come back to Black Tap Memorandum of Association.
How does that help you, Mr. Iqbal?
Yes.
Because if that's right, then the heads of agreement is also contrary to public policy, isn't it?
The heads of agreement refers to a number of other clauses. For example, let's get to heads of agreement, a nominee agreement. Sorry, I beg your pardon, my lord. Did my lord refer to the heads of agreement or to the nominee agreements?
No, the heads of agreement. If the nominee agreements are all contrary to public policy, why isn't the heads of agreement also? Because it's plainly envisages nominee ownership of shares, and nominee ownership means that the nominee does what the ultimate beneficial owner requires. Now, I know there's an argument between you, a dispute, as to what the true effect of the heads of agreement is, and it's said that it's procured by misrepresentations, that she would have beneficial interests and so on and so forth. But once we get into the public policy argument, it appears to me that one's looking at the question of public policy across the board in relation to the whole arrangement. And that's plainly not a matter for summary judgment, immediate judgment. It's a matter that will have to be explored in some depth. Excuse me. And I take it, subject to what anybody says, in relation to the other proceedings first. I'm not quite sure how far the other proceedings have got, CFI-024.
Yes. My lord, insofar as the other, just a quick response to that, the other proceedings are before the Court of Appeal in relation to a specific matter. And the specific matter is that whether or not the defendant in that particular claim should be able to I'm trying to recall on top of my head the contention in the other claim.
Well,
yes.
Tell me how far that's got, actually, first of all. I mean, it was begun in March, as I understand it, of this year. It's proceeded through the pleading stage. Has there been disclosure?
The answer is no, and that is because the other claim was initiated under Part 8 procedure by, yes, and Ms. Elhers made an application for that Part 8 proceedings to be transferred to Part 7 procedure. That was refused at first instance. Against that, she has been granted permission to appeal to the Court of Appeal, and the substantive appeal is listed for hearing on 18th of January.
Right. So that appeal is in relation to whether or not it should proceed as a Part 7 or a Part 8. Is that right?
That is indeed correct, yes.
Yes, okay.
Just for the sake of completeness, in this particular claim, Ms. Elhers, in her particulars, did apply for the two claims to be conjoined, but the defendants did. Yes. Anyway, so coming back to the point that your lordship made in relation to the heads of agreement.
Yes.
Yes.
I want to ask one or two more questions, but you deal with that point first.
Indeed. Now, first of all, I have to say that I can assure the court that I do understand the delicacy / the depth of the observation that your lordship has made at this point. However, doing my best, the reply that I would submit is that we have already seen clause 7.8 of the Memorandum of Association at page number 88, which requires that the transfer must not result in reduction of the aggregate of shares of UAE nationals in the capital of the company to less than 51%. So what we actually say is that she holds 51% shares in Brick Oven and Black Tap. That is in compliance with the federal policy. If she were to transfer those shares to anyone, any non-UAE national, only then that would be contrary to the public policy. Now, what we say that what reinforces our argument is that the defendants themselves understood and knew that the two nominee agreements will be falling foul of the federal policy unless, to the defendant's understanding, if parties subject themselves to the jurisdiction of DIFC courts, which will interpret the agreements in relation to whether there is a promise, whether there is a breach, and whether there is a loss. So what we say is that the defendants did acknowledge, yet they run the risk of putting the two nominee agreements. Now, insofar as the heads of agreement is concerned, the heads of agreement, first of all, goes to the extent of requiring Ms. Al-Hurst to retain 51% shares. It doesn't require Ms. Al-Hurst to transfer 51% shares. And that's what the nominee agreements require.
Well, I understand that, but if one looks at the thing in the round, and it seems to be any judge is likely to do that, he's going to say, if you're right about the public policy issue and the federal law, meaning that you simply can't do what has been suggested, you can't have a true nominee arrangement whereby one party, a national, holds 51% of the shares as nominee for a foreigner who exercises real control, the whole of the arrangement falls to the ground. And the question then, which the court always has to decide as a matter of public policy and law, is what happens. And one would suspect the answer is the whole thing has to be wound up, which may be what neither party wants, I don't know. But it's very hard to see how the court could sanction any kind of arrangement between parties who, on your case, have quite deliberately flouted the law. I mean, I say that because as a judge of the court, that just appears to me to be the obvious conclusion that any judge is likely to reach. On your case, both parties knew that the arrangements were not appropriate. They were unlawful, contrary to the law of the DIFC. And if it's the sort of law that requires the court to say, well, you just can't do that, the court will take a very severe view about it.
Yes.
And that would be the end of both CFI-024 and this case as well. Now, before you answer that, and I appreciate that's a difficulty that we don't, in one sense, have to grapple with today. It appears to me to be a matter that would have to be dealt with fully at a trial of some kind. Possibly, if it's purely a matter of law, then it could be dealt with under part, whichever it is, part 8, as opposed to part 7. But, or is it the other way around? Whichever way it is. But it does appear to me to be a matter that requires full exploration. And personally, if I was looking at it, I would want to have all the facts, which would mean that I would want it to take place with particulars of claim and so on and so forth, and disclosure and all the rest of it.
Yes.
So that's really the major difficulty that I see with the court even beginning to think about it on an application for immediate judgment.
Yes. My Lord, I take the point. What I submit is that prior to today, the point which in the form of, at the moment, an observation your Lordship has made was not raised by the defendant, so I did not explore that point in as much detail as it requires. Nevertheless, we say that this is not the only point on which the present application is brought before court. The one point that I've already made, this is the second point, and without delving further into this particular point, at this point in time, and without having done further research as this point requires, I would seek to move on to a third point on the basis of which we are seeking a strikeout / summary judgment to the relevant parts of the pleadings. And that is, as I have said in my supplementary skeleton arguments, that the nominee agreements are incomplete, i.e. that both parties kept to themselves, to be agreed at a later stage, the consideration. If we can go back to, my lord, page number 151, which is Black Tap nominee agreement.
Yes.
It's the bottom middle of each page.
Yes.
And it's clause 3.
Yes.
Now here, it reflects that there is a consideration in the sum of 10,000 AED that's been agreed.
Yes.
Well, first of all, it's a common ground that even if this was the agreed price, it's never paid by the defendants to the claimant. That's the common ground. However, we say that this paragraph 3.1, this clause, does not reflect the reality. If I can now make a reference to page 164, please.
Yes. Hold on.
Okay.
Bear with me. I have to go back to the index.
Okay, ma'am.
Yes. Are we looking at the 18th of December email?
My lord, yes.
Yeah.
So we say that that's quite a clear, unequivocal statement by Mr. Gonzalez, saying that we still need to find a final agreement over this, whether in the form of shareholder and sunset group or an agreement for this outlet.
What does an agreement for this outlet mean?
Well, that's in relation to Brick Oven outlet, because I think Brick Oven was a restaurant, a coffee restaurant.
Yes. Right. But what, when it's, I mean, I understand shareholding, but what is referred to as an agreement for this outlet? What sort of agreement are they talking about? For lack of instructions on this particular point, I'm reluctant to answer that, my lord. I have no instructions on this particular point. Agreement for this outlet. Yeah. Anyway, what you say is they envisaged a further agreement being made. I understand that.
Yes. And my lord, yes, that's the point that we make in relation to this particular clause of this agreement. That is the point that I have made in my skeleton arguments from paragraphs number 20. I needn't take your lordship through the extract that I have copied in my skeleton arguments from Chitty and Contract. And also, I don't think that I would need to take your lordship through the case of Willis Management in my skeleton arguments I have referred to. So I'm deliberately skipping them through unless I can give any assistance to your lordship on any of those points in my skeleton arguments.
Well, your problem is this, isn't it? That on the face of it, the contract itself provides the consideration, but the parties envisaged a further agreement being made, which would have changed that. But I don't see quite how that gets you home.
Well, the first point is that, first of all, if there was any other agreement, such as the heads of agreement, that were to provide consideration for the services provided under either of the two nominee agreements, then there would have been no reason for the parties to agree on any other consideration. There would have been no reason for clause 3.1 or for that particular email wherein the parties were leaving for themselves the door open for further agreement. But that is what these documents reflect.
Well, yeah. The difficulty is this, isn't it, Mr. Iqbal? We've got, in addition to all this, you've got an entitlement to 2.5% shares in Sunset RAK. You've got an option for further shares, further 2.5%, and there's an argument about whether or not you've been prevented from exercising that option and so on and so forth. So there's obviously more to this than simply the nominee factor. One understands that. But where you've got an agreement that says we've got 10,000 UAE dinars to be dirhams to be payable, it doesn't seem to me that you can say there is no consideration on the face of it. There is a promised consideration. If it hasn't been paid, then of course you're entitled to claim it. But the fact that the parties envisaged that there would be further agreements doesn't invalidate this particular one on that basis alone. I just don't see how the point works here.
Well, our point, what we say is that, first of all, on the face of it, there is a clear disparity between clause 3.1 and the email of 18th of December. They two cannot and do not go hand in hand. So, and what we say, what's obvious is that because the email of 18th of December was subsequent to these nominee agreements, that...
But it's the same day, isn't it?
Well, yes, indeed, that is the same day. Well, sorry, 18th of December 2016, yes. Yeah. So what we say is that the plain reading of the email suggests that clause 3.1 is just symbolic. It does not reflect the reality.
Yeah, understood.
So therefore we say that out of this agreement, there still remains an important and crucial element to be discussed between the parties, and unless that is done, the agreement was not concluded. It remains an incomplete agreement, hence void for uncertainty. And if the agreement is void for uncertainty, the cross-default clause cannot rely on this, and the mother agreement cannot be brought to an end.
Understood.
In the skeleton arguments, my lord, I've already made another point that by the time the mother agreement was executed between the parties, the brick oven did not even exist. And
Well,
brick
there's an issue about that, isn't there, about the timing of the heads of agreement? Because the email suggests that it wasn't made and wasn't actually executed until at least April and possibly May of the following year, although it's dated as of the 1st of July. And it's interesting that it does specifically say effective date as of. We've got two nominee agreements, haven't we? The 18th of December and the 25th of May. So who knows quite what the position is?
Yes. Well,
what do you say about the actual date of execution of the heads of agreement?
Well,
do you have a date for when that was actually executed? Is it between the dates of these two nominee agreements, between the 18th of December and the 25th of May?
Well, my instructions are that the date of the agreement is 1st of July, as it is reflected on the heads of agreement.
But you must have seen the emails where there's discussion about whether or not it should be dated the 1st of May 2017. Should be execution date. So it can't have been executed by then, can it?
Oh, yes.
About the 12th of April, I think, is the email, if I remember rightly. I can't lay my hands on it immediately. But on the face of that email, it looks as though it hadn't been executed by April the following year, April 2017.
Yeah,
and the way I'd read it, or at least the way I was thinking, is that it probably is actually executed around April, May, but before the date of the brick oven nominee agreement. Yeah. That's what it looks like without being able to say the specific date.
Yes, it's page number 329.
Oh, thank you.
Can you hear me?
Yes.
Very good. I just might be able to assist on that very briefly, and I can refer you later to the evidence, which actually is the specific evidence is in the other case. But the agreement was signed after the 12th of April 2017.
Well, that's because of that email. Yeah.
Yes. But
and that the one? Is that page 329 that Mr. Iqbal was just referring to?
Yes, indeed. 329 to 331.
Thank you. Okay, we needn't go there for the moment. Do you have any submission to make about that, Mr. Iqbal, or doesn't it matter?
Well, in fact, I was going to make a submission on a slightly different point. That is in relation to brick oven. Now, in brick oven, at page number 158.
Yes.
The point I made is, clause 5.1 says the nominee acknowledges that he is the custodian, fiduciary agent and trustee.
Yes.
And that agreement is 25th of May 2017.
Yes.
If we compare that with page number 111, that is where we have the memorandum of agreement.
Yes.
That reflects 51% shareholding of Ms. Al-Hers. That memorandum is 3rd of July.
Yes.
So what we say that on 25th of May, it was not possible for the parties to say that the nominee acknowledges that he is the custodian because no shares were in existence at that particular point in time. So the point I'm making is that brick oven agreement, on the face of it, does not reflect reality in clause 5.5, and similarly clause 3.1, which is the consideration clause, about 72,000 Arab Emirati dirhams.
Yes.
Anyhow, again, moving swiftly to the other points. Yes, and just briefly, as in my skeleton arguments, I have put from paragraphs 39 onwards that insofar as the particular default cross clause is concerned, Ms. Elhers did not give any guarantee, or neither was she required to give any guarantee, whereas she could have been asked, and no reason if she had been asked she could have provided that. So the point I've made in my skeleton argument is that there is no animus contrahendi between Ms. Elhers and either Sunset Rack or Petura.
Yeah.
My lord, one last point, and that is that as I understand, the defendant's argument is based on Chitian contract, that although the cross-default clauses are common in credit lending agreements, they can be applied to commercial agreements. My response to that is, first, is I have carefully read the skeleton arguments by my learned friend, Mr. Dylan Malone. He has referred to a number of authorities, for example, Rahman and HSBC, Adair Finance, ZCCM Investments, Abu Dhabi Commercial Bank PJSC. All of those involve cross-default clauses in relation to credit lending agreements and not in relation to any of the commercial agreements. As opposed to the credit lending agreements, the agreements that we have, I would call them executory contracts. And in relation to executory contract and the application of default cross-default clauses, I could not find any case in English jurisdiction, although I have done some research, and from the New York state in the United States, I have come up with a case of Cooke that I have referred to in my skeleton arguments.
That's an insolvency case, though, isn't it?
I beg your pardon, my lord?
That has insolvency ramifications, which is why there's a particular problem.
Well, yes,
and I think the problem is this. Again, Mr. Iqbal, the problem is this, isn't it? There's no reason in principle, as a matter of contract, why parties can't agree that any breach of any other contract of a connected or even an unconnected nature can constitute a default, which allows for various remedies to be affected, unless there is a provision that says that you can only have a cross default in a credit or securities agreement of some kind. Why, as a matter of principle, can't you have it in a contract of this kind?
My lord, I have very frankly admitted that principle in my skeleton arguments. Yeah. We say that, yes, in principle it can be done. But however, it cannot be left unbridled. There has to be some boundaries attached to that. And the defendants have not even said a word. They have just left it so wide, so open-ended, that it knows no bounds. What I have attempted to submit in my skeleton arguments by making a reference to Cooke, that yes, it has ramification in relation to bankruptcy, but I've carefully used the word in my skeleton that it gives persuasive guidance on that. Now, the guidance that I submit is that, number one, in the agreement in Cooke, there is an amalgam of credit lending plus the executory contracts. Because in Cooke there were three contracts. First was the sale of the veterinary practice. Second was the consultancy agreement. And the third was the lease agreement. Lease was the executory agreement. Now, in that case, the court had considered a number of previous historic authorities, and on the basis of that analysis, the court found that in order for cross-default clauses to be applied to commercial contracts / executory contracts, what the court must look at, that if, even for argument's sake, the cross-default clause is put to one side, and then analyze whether or not the parties would have gone into the transaction or not. On the facts of Recopel, the court decided the parties could not have gone into the transaction without the cross-default clause, because otherwise it would have thwarted the bargain between the parties. Furthermore, in Recopel, the court has referred to two cases. For example, if I can just make a quick reference to the case of in re-wheeling Pittsburgh Steel Corporation. Now, in that, there were 5 insurance contracts. One insurance contract, the terms of that had already been breached, but it was in relation to the remaining 4 insurance contracts about which there was a litigation in the court. The insurance companies wanted the 4 insurance agreements to be lifted, a stay to be lifted from the 4 insurance agreements, because the insurance company pleaded that the cross-default clause was present in all the 5 agreements. The court rejected the point, saying that the 5th agreement in which there had been a breach, that matter had already been settled earlier. So it had no connection with the remaining 4 insurance agreements. Similarly, our point is that if we apply the guidance from Recopel to the facts of this case, if there was no cross-default clause, the defendant would certainly have gone into the heads of agreement, and their bargain would not have been thwarted. In any event, the refusal of Ms. El-Hers to transfer the 50% shareholding does not expose the defendants to any loss, because the businesses are still running. They have not pleaded any loss in relation to that. So my submission is that although in principle cross-default clauses can be applied to commercial contracts, but not so widely and so open-endedly as the defendants may have attempted to persuade this court. What I say, that this court can seek some help from the case in Recopel, and there is no reason in principle why it should not. My Lord, unless I can offer any further assistance, I'm reluctant to stretch my arguments any longer, because I have pleaded most of it in my skeleton arguments.
Very good. Thank you very much, Mr. Iqbal.
Grateful, my Lord.
Yes.
Thank you very much, Judge. Just taking the last point first, I think the natural point to begin when one's looking at this case, it is a case primarily of construction, and of construction of the cross-default clause is the, as Mr. Iqbal has indicated, is at the heart of his application today. And I want to start today by focusing on the question of construction of the clause by reference to some of the materials that I've put through the course. I think that should take me about 20 minutes. And then, with your permission, I propose to move to what I may call the legal aspects of the application in terms of the alleged unenforceability or problems with the cross-default clause that have been identified by the claimant in its application. But
well,
to start,
I don't think I need to hear you on the point of construction.
yes,
Mr. Iqbal has wisely not spent any time on that.
okay.
Really, I think the what I would like you to do is to deal with the arguments that Mr. Iqbal has raised today, rather than those that are simply in his skeleton.
Yes.
In particular, in relation to the question of illegality and unenforceability,
yes,
by reference to the federal law and what the impact of that might have, and
yes,
then the impact of the cost default clause as opposed to what it, how it's to be construed, and whether or not there are any limits that fall to be imposed in relation to it.
yes.
I think those are the main points, if I do Mr. Iqbal's submissions justice, that I would like you to deal with.
Thank you very much. Might I just spend 3 minutes then just identifying the arguments that I'll be leaving behind? And yes, they are, first of all, on the construction, the starting point that one approaches the question of construction on the plain meaning as per the DIFC contract law provisions from Article 49 to 53 of the DIFC contract law, supported by paragraph 82 to 84 of the DAMAC judgment, where we talk about the commercial object and business common sense interpretation of the clause. And in addition, here we have contemporaneous record from the emails at 329 to 331 indicating which is permissible evidence under the DIFC contract law under Article 51C, the true character of the clause and the intention of the parties. The common intention of the parties is very clear in our submission, and if one wishes, one can then even adopt the iterative approach, which is discussed at paragraphs 42 to 43 of the DAMAC judgment, and test the various rival meanings and other provisions in the document by reference to the commercial consequences of the clause. And I say that all of those give rise to a straightforward construction which readily identify the common intention of the parties in creating a cross-default mechanism whereby Ms. Hertz is taking on the role of nominee as 51% shareholder under these arrangements, an important role, and therefore a mechanism is put in place under the mother agreement, as Mr. Iqbal describes it, whereby any default, including a serious repudiation of her obligations as nominee, can be met by a corresponding remedy, in this case, termination of the heads of agreement. So all of that is very clear. And then I think what we've identified on our side for the purposes of today, and I won't address you on them, were the arguments. There was a twin argument of consideration, which was linked to an idea of uncertainty. And I think, subject to your lordship, I believe from what you say, I don't need to address you on those. I've heard...
I don't think so. It appears to me on the face that the contract contains consideration. Whether it was paid or not is neither here nor there for this purpose. Yes. Of course, how it links, what the interrelationship is between the fees under the nominee agreement on the one hand and the figures that are referred to in the heads of agreement on the other is I mean, it's all rather unclear, isn't it?
Yes. I just refer you to one aspect, which is on the first page, page 125 of the heads of agreement, 3/4 of the way down, before the definition of services, it actually says, as consideration for fixed cents providing the services to Sunset Holdings. Sunset Holdings shall enter into the various transactions set out below in this agreement. So there is on the face of the heads of agreement, reference to non-monetary consideration in addition to the monetary consideration which is identifiable from the agreements taken together.
Well, that doesn't help you very much, does it? Because there aren't any transactions actually set out below in this agreement. There's reference to the possibility of further agreements with subsidiaries and affiliates. But there aren't any transactions as such set out at all.
Well, I think that the nominee agreements are anticipated.
Well, you can say that, but there's no express reference to that, is there?
No, apart from in A, under the definition of services.
Yeah.
So I think the point still stands, if I may say, that there are construed as a whole the narrow focus on the consideration owing under the specific clauses in the nominee agreements is not the full picture, and we have a series of agreements which are connected here. And in our respectful submission, there's no uncertainty of the type that is put forward by Mr. Iqbal in his skeleton arguments. The second general point is the one on privity. And we've made the point in our skeleton, it hasn't been pushed today, but we've made the point that it's better to look, it's the correct way in our submission to look at this, the character of a cross-default clause, is that it defines an event of default. It's a pre-agreed definition of a between the contracting parties and albeit to an external event of default. And then we've referred to the case law, including in particular Adair, where we see that these types of clauses in general are enforced where there's a legitimate interest and where it's not disproportionate to the intentions and commercial objectives of the parties. And here we are comfortably within that in my submission. I wanted to bring you very briefly to Adair, but I can refer you to the paragraph number instead, and that's, you'll see from paragraph 100 to 105 of the Adair judgment of Peter MacDonald Eggers QC. There's the references to the test.
Can you give me the cross-reference in your skeleton?
Yes, indeed. Excuse me, I haven't been looking at my skeleton. It's paragraph 31.
Yes.
But the particular test at paragraph 103 of Adair on page 481 of the bundle is the reference to legitimate interests. And you'll see also a discussion of whether there is proportionality in the arrangements. And it is a principle of DIFC contract law, as your lordship has identified, that parties are free to contract. The suggestion that cross-default clauses are something which only operate in the realm of financial loan documentation is not correct. They were described as ubiquitous by, can you see me? Can you hear me? Can you hear me, Judge? Is everybody hearing me?
I can hear you, I can hear you.
I can hear you as well, Patrick.
Judge, are you catching me? Judge, I'm not sure whether you can hear me. Should I continue? I'm just wondering, is Justice Cooke hearing me still? Judge, are you hearing me?
No.
I don't know whether you can hear me.
Patrick, I think the judge, so he was connected by phone and I don't see him connected anymore, so I'll connect him again to the call, okay?
Okay, very good.
Okay.
Thank you. Thank you very much.
Hello, I'm back again. Sorry about that. The telephone connection went. I'm doing a mix of both the visual and the telephone. But anyway, we're back on. You were just about. You were dealing with page 481 of the bundle and Adari, and you've dealt with legitimate interest and proportionate to the general objective.
Thank you. And that just shows that the combination of visual and audio works, because I eventually did understand your holding up the telephone. I got your visual cue. I have lost you, though, on the picture. It would be helpful to me to see you again, but I'll continue and see whether you pop up again.
I don't know why you lost me. I'm appearing on my picture. And I can see you.
Very good.
Judge, I can't see you either.
Let me try again. Any good?
Not
started
still.
the video and I can see myself in the corner.
There might be a blue disc that looks like a camera icon with an X on it.
No, I've done that.
Yeah.
I'll stop it and start it again and see if it makes any difference.
Thank you.
Start my video again. Can you see me now?
No, not yet. I'll continue, Judge, and with your permission.
Yes. Well, you won't know if I'm laughing or crying, but there it is.
Very good. Well, I think I was referring to the reference internally on page 479 of that judgment to the submissions of David Allison QC, which was cited by Judge Eggers in that Adair case. And he refers there to the ubiquitous character of cross-default clauses in commercial loans. But in our respectful submission, as you have identified, the freedom of contract that underpins DIFC contract law is reflected in the law itself, is wide, and there is no reason in principle why, in a case such as this, and this is a very good example of where a cross-default clause exists for good reason, to provide for a necessary and proportionate and legitimate trigger for the termination of the heads of agreement in the event of a repudiatory breach of the nominee agreements. We remember that Ms. Hertz is the 99% shareholder of Fixed Sense. Fixed Sense entered into this agreement. She entered into it with them, in effect, and they entered into this arrangement knowing that the principal service being provided would be under nominee agreements. And that has been indeed urged upon this court today by Mr. Iqbal. So The privity argument in our respectful submission is misconceived. The enforceability of these clauses more generally is established, and in our respectful submission, it's not an appropriate, it's not a likely argument to win the day, still less on the immediate judgment application today. That brings me then, I think, to the points that you wanted me to address specifically. The public policy aspect is interesting. I suppose in the background there are reforms going on at federal level in relation to the commercial companies law. It is a public policy that, of course, in this case will be viewed as it applies to companies governed by the commercial companies law. And therefore, there's no difference between that public policy as it applies in the DIFC and that public policy as it may apply before an onshore court. Now, there has been some discussion, Judge, by Justice Al-Sawalehi in an arbitration case, which the judgment was actually anonymized and made public last year. I think it may date from late 2019, in which he gave some consideration to whether there was a difference in the use of the word public policy in the DIFC in the context of the DIFC arbitration law and public policy of the state, of the wider UAE. And it's an interesting judgment, which gives rise to the notion that it is more or less a unitary concept of public policy throughout the UAE, viewed internationally, but that there can be some deviation or variation within the Emirates and within onshore entities, within onshore jurisdictions. But here that doesn't really apply, because the public policy we're looking at, of course, is the public policy as it applies under the commercial companies law, therefore to companies that are governed by onshore UAE law. And a unitary approach will presumably be adopted to it. We say that in this case, clearly, as you have said, that is the subject of the other proceedings, which is primarily an argument which is fully joined in case CFI-059-24. The Court of Appeal hearing on there were three applications, the subject of that appeal. One was the filing of a counterclaim at quite a late stage, the introduction of evidence at that same late stage, and the application to transfer Part 7 to Part 8 to Part 7, right before a matter of days before the listing of the hearing of the Part 8 proceeding was about to take place. And effectively, those three applications came in unannounced and effectively derailed that Part 8 hearing. Justice Al-Sawalehi refused all three applications, and those applications are now the subject of the appeal to the Court of Appeal. But eventually, things will get back on track in that case. I'd
like to discuss with you at some point what the future progress of both sets of proceedings might be.
Yes.
Particularly if wider issues are to arise in one or the other. And I suppose that may depend on what the Court of Appeal has to say. So we might wait until that. But
yes, I think I have to be.
I'm very troubled. I'm very troubled by the fact that it appears to me there is no possibility that I can grapple with issues of public policy on an immediate judgment application of this kind. But
yes,
when one gets to those questions, if they arise in this action, they plainly interrelate with the other action. and on the face of it, apply across the board to all the arrangements between the parties, who have to be seen for this purpose, it seems to me, as being in pari delicto, as we used to say, in the context of illegality, or all the more recent illegality cases. And quite what the impact of that would be is, well, it's highly questionable, isn't it?
Yes. I think certainly there are, as you say, there are factual questions that would, the context for these particular arrangements might have to be elaborated on in proceedings. I have to be aware of my own instructions in relation to the Part 8, Part 7 aspect. It will be remembered that we brought the original proceedings, my client brought the original proceedings simply for the purposes of a specific performance and declaration that these shares, which were nominee shares, ought to be transferred pursuant to a specific obligation which had been contractually agreed by Ms. Hertz. So now the second set of
you've got a Court of Appeal decision. You've got a Court of Appeal hearing on the 18th of January, I understand it.
Yes. On those applications, it's that will be a bump in the road, and as you say, I can't predict entirely right now what the procedural course will be, but certainly I think I must accept that the public policy issue that is more to the fore and properly joined on the pleadings of the CFI-24, that would appear to be the correct case in which the public policy argument would be advanced. There may also be questions relating to how this case will be managed in the light of developments in that case. I think, as your Lordship anticipates, our position to date has been that we wanted to keep things simple, that we believed we had a straightforward contractual obligation to enforce, and therefore we have not advanced or agreed to a consolidation of the two proceedings. I don't think they'd be appropriate for consolidation, but they might be appropriate for case management in a sequential type of way.
Well, they might be appropriate to be heard together. If
yes,
the
that's what I
evidence
mean.
If the evidence in one is essentially evidence in the other. I mean, all of this is a bit premature, but I'm bound to say that if, obviously a lot depends on what the Court of Appeal has to say, but if the public policy argument applies, and it is after all being run in this case now, it must apply across the board, and I would have thought therefore it becomes appropriate, whatever the Court of Appeal says probably, if the cases are to continue, for them to be case managed together and a decision made as to how they run together. Mr. Iqbal, are you instructed in the other matter in CFI 24?
My lord, yes, I am.
Right. So there's no difficulty from that perspective. You're both instructed in both.
I am, yes.
Right. Okay. We'll come back to that at the end of today's hearing and see what, if anything, needs to be done in relation to that.
Yes.
Very good. All right. I've interrupted you enough at the moment.
Thank you.
You carry on.
Judge, can I just address you on just one particular point in relation to public policy that you mentioned, or 2 points actually. First of all, was the, as you have said, the impact of a finding of that there is a contravention of public policy may have the effect of there being a plague on all houses, of course, and that is something which equally would need to be explored at a full hearing of either or both cases. Secondly, I think Mr. Iqbal mentioned in the course of his submission that the illegality would come from the transfer to a national that was not a UAE national. And in this particular case, the evidence is, I can tell you, Lordship, I don't have a reference to it right here, but it is in evidence that requests were made to Ms. Hertz to transfer to a UAE national. So there is not any proposed illegality. And on the face, and our submission as a matter of generally stepping back from it is that there is no necessary conflict between the nominee agreement in this case, or more generally, and the commercial companies law. Indeed, the agreements are there to preserve respect for the commercial companies law, and whereas there have been arguments that these are false arrangements in our submission based on the onshore cases and on proper construction of the company's law, there will be no violation of public policy at the end of the day.
I understand the argument both ways, but there plainly is room for arguing that a nominee arrangement falls foul of the CCO. I don't know whether it's a commonplace or not in the DIFC to have nominee shareholdings of this kind, with a national holding 51%, but only as nominee and taking instructions as to voting and everything else from the ultimate beneficial owner. But it's obviously a highly important point, and if it's going to be decided, it's got to be decided on full facts and full argument.
Yes. I think it is it's common in onshore arrangements, precisely because it's the commercial companies law under the UAE federal arrangements where the issue arises. The question then of the impact of the clause, I think that was the second area. I'll be very brief. I think the argument is that there's a contradiction between the nominee agreement and the heads of agreement, to the extent that the nominee agreements, if they come to an end, they're terminated. Then the heads of agreement, there's a suggestion that in some way the heads of agreement is perpetual, and that's clearly just not the case. In the first case, as you have said, the definition of group companies on page 125, on the first page of the heads of agreement, is wide enough and embraces more than these two particular nominee companies. And if the nominee arrangements under those nominee agreements come to an end, the heads of agreement will survive independently, and there is no evidence before this court as to the extent as to the full extent of the group companies, and of course but that's irrelevant in any case, because there could still be other nominee companies and nominee arrangements which might come into being, and they'd be covered by the umbrella of the heads of agreement. So I think that the idea that that the obligation to transfer upon request in the nominee agreements is in some way a contradiction of the heads of agreement is misconceived. And indeed, on page 1 of the heads of agreement, on page 125, you can see that it says as and when requested. It's again on that same page I just referred to. The definition of fixed sense services. Fixed sense as a shareholder shall provide services to Sunset Holdings as may be reasonably and permitted by law, as and when requested by Sunset Holdings. So it's anticipated that this will be, these are matters that can ebb and flow at the request of my client. Judge, was there another aspect that you wanted me to address you on the effect of the clause?
Let me just check my notes here. No, I think that covers the essential point. Thank you.
Yes. I think maybe just one last point, Judge, is that I referred to it in our skeleton, but it's a little bit oblique, but nonetheless the precedent of Lord Justice Mummery's analysis of a cross-default clause in the case of situ adventures. It's just a few paragraphs. It's at paragraphs 8 to 11, 8 to 12 of that judgment. It's an example of where the suggestion was made, which was not unlike the suggestion being made by the claimant here, that there would have to be something near privity to bring a cross-default clause into the category of enforceable, and it was at paragraph 12 of that judgment, Lord Justice Mummery deals with that argument and says no, this was properly triggered, notwithstanding that the parties were not the same and the entities were not the same.
I'm afraid I've completely lost you there. Where are you referring to in your skeleton?
I've referred in the paragraph 34.
Yes.
To a judgment called situ ventures.
Yes.
Oh, I'm sorry. I'm sorry, Judge. Excuse me. I'm mixing myself up. That was the judgment where the and/or point was made.
Yeah, exactly. I don't think we need to trouble ourselves with that.
No, there was a. Sorry, it's the other judgment. Excuse me. Terribly sorry. Let me just find it here.
Well, that's where I'd lost you, because I wasn't quite sure what you were referring to.
Yes. I'm sorry, just 1 second. Sorry, Judge. I'm finding my papers. Excuse me.
All right, take your time.
Yes. Yes, it's the Abu Dhabi commercial judgment case. It's on page 452 to 453, and it's a judgment of Justice Michael Brindle QC, and very simply he identifies the issue paragraph 7 to 11, and then he deals with it at paragraph 12 of that judgment. And in my respected submission, that's an example of a near privity type argument being advanced and being neatly and succinctly dealt with by Michael Brindle QC at paragraph 12.
Yeah, okay.
And those are my submissions, subject to any questions.
No, thank you very much. Mr. Iqbal.
Thank you, my lord. Very briefly, a few bullet points. First, my learned friend submitted that in relation to the privity argument that was not pushed today, well, I deny that. The fact that if I have not orally developed any argument today, it doesn't mean that I seek to abandon the argument that I have raised my skeleton arguments. Nevertheless, when I refer to no or lack of animus contra handi between Mrs. Alherz and Sunset Rack, I did refer to that as well. Furthermore,
I've got those points, Mr. Iqbal. Don't worry, I'm not going to ignore them.
I'm very grateful, my lord. Secondly, my learned friend, in relation to public policy argument, referred to some discussions / developments at the federal level about the public policy, and also referred to an arbitration award by Judge Al-Swalehi. I'm sure the court would appreciate that neither the court nor do I have any of that information available. So I would respectfully invite the court to please ignore that. And do not allow that to have any bearing on the argument at hand at the moment. Another bullet point that I would like to address is that in relation to consideration and this point is about whether in the mother agreement there might be any agreement between Fixsense / Ms. Alherz and the defendants. My submission is that this case is to be decided on the basis of the facts that exist on ground, not what might be. That's a pure speculation which may or may not happen. The ground reality is that there are two companies, Black Tap and Brick Oven, and those are the two ventures which are the subject of the mother agreement, and the shareholding relates to that, and the whole transaction revolves around those. And the centerpiece, as I've already submitted, is to hold the 51% shareholdings in those companies, and that goes to the heart of the agreement. If she returns the 51% shareholding, then there is no purpose of the mother agreement, because clause A of services in mother agreement is the unique selling point of Ms. Alherz. The remaining services from B to D she did provide, but they can be something that the general manager could have done himself. Moving on, another bullet point reply. The general application of cross-default clause in commercial agreements. I would make a very short point, and that is that in the case of Rico Pell, there was another case which was referred to and discussed. That's the case of in Re Sambo's Restaurant Incorporated. Therein, there were 8 leases, and each of the leases had a cross-default clause in between. The claimants defaulted on 2 lease agreements and did not default on the remaining 6. They wanted to assign the 2 lease agreements on which they had defaulted, and for the reorganization they made an application to the bankruptcy court. The defendants opposed on the basis that because of the default clauses, it was a case of take all or leave all. And they pleaded that the claimants could not assign the 2 lease contracts, rather they were to cure the defects on the 2 lease contracts and keep all 8 leases. And in relation to that, the court said that cross-default provisions represent an impermissible restriction on the debtor's ability to assume and assign contract. And if we borrow that guidance by analogy and apply to the facts of this case, we submit that clauses 5.5 in the two nominee agreements, they place an impermissible obligation on Miss Elhers, because to comply with that obligation, she would lose the benefits out of the mother agreement. And lastly, my lord, yes, one last point, just so that I do not stand accused of abandoning that point, that's in relation to 2.5% shareholdings, in relation to which the defendants have in their defense pleaded that that is in relation to an oversight on their part. We say that that amounts to an admission. And at the very least, a summary judgment can be granted in relation to 2.5% shareholding in Sunset Rack. Unless, my lord, I can be of any further assistance.
Well, let me just ask a question about that last point. I had understood that essentially an offer's been made to make that transfer, and that can take place outside the court proceedings. I don't see any reason why the court should give judgment. Is there any reason why that transfer shouldn't take place? It's common ground that your client's entitled to 2.5%.
My lord, yes.
Either party have instructions on that. You know, this has been common ground since the defence was raised.
Yes.
Yes,
what needs to be done in order to make the transfer? I mean, it's literally just a matter of signing the transfer to whoever your client wishes it to go to. Is that right?
Judge, I can assist on that. The evidence and the pleadings are that in our defence and in witness statements is that we have undertaken to transfer those on request, and there has been no request since we undertook and pleaded the point.
Right. Well, is the request now being made? I think it seems to me apparent that it is. I'm being asked to give judgment. I take that as being a request, and you should make the transfer, shouldn't you?
I assume so. I presume there are signatures to be acquired, but I think it would be wise for the legal representatives of Fixed Sense to please send us to communicate the request to us, and we will immediately act on it.
Mr. Iqbal, I know you. I don't think this is in reality going to have any impact on cost issues, but is it simply a question from your perspective of a transfer being signed to HA herself, or to Fixed Sense, or to whoever it is you say the transfer should go to?
My lord, I apologize. I think it's a bad line. I could not really grasp what your lordship said.
Well, there seems to be a sort of argument of circularity here.
Yes.
It's common ground, and has been since the defence was served, that your client is entitled to the 2.5% shareholding. So my question is, what actually needs to be done in order to achieve that? Mr. Malone says that they want you to make a request. Well, I take it you've made that request, haven't you?
I have indeed, yes.
Right. And to whom is the transfer to be made?
Well, that is to fix sense, because they are the party to the mother agreement.
Right. Very good. Well, it seems to me that that transfer should be made. I don't think I would propose to make an order on that, but if no transfer is effected within, let's say, 14 days, then I would be open to an application for an order for specific performance.
I'm grateful, my lord.
It's common ground between the parties, so it ought to be done. All right. Leaving that point to one side, I'm not going to give judgment now, but I'm going to tell you the result, and you'll get the reasons in writing. The application fails. I do not consider that this is an appropriate case for immediate judgment. There are issues which arise which require determination on the facts, and they may indeed trespass into the area of the other case, where we will await what the Court of Appeal has to say. But once the Court of Appeal has made its decision, it seems to me that the case management conference should be organised in relation to this matter, with sufficient time for the parties to consider the Court of Appeal decision and the impact that that may have on the conduct of this matter and that matter. Self-evidently, if the Court of Appeal decides that the other matter should also become a Part 7 case, then it would be open for the two cases to be case managed together and indeed be heard together. If they decide it not to be a Part 7 case, then we'll have to consider what happens next in relation to both. But self-evidently, it seems to me the two should be brought back before this court once the Court of Appeal has made its decision, and that matter should come back before a judge as opposed to the judicial officer. And we'll see where we go from there. I'll give a written judgment in relation to all the arguments that have been raised today, but you can take it that the application for immediate judgment fails. I shall want to know why there hasn't been a transfer of 2.5% shares if that doesn't take place within, let's say, 2 weeks, unless Mr. Dylan Malone thinks he needs more time to make a transfer.
I'm simply unaware of the procedure, the precise procedure.
I'd imagine Dylan Malone, if there's any difficulty about that, but on the face of it, 2 weeks ought to be plenty of time. You know it's to go to fix it, so it's just a matter of signing the relevant document.
Yes, and the register.
Well, indeed, and entry on the register, self-evidently, yeah.
Yes.
Yeah. All right. Now,
Judge, might I ask, in the circumstances, I applied for the costs of the application and to be given by way of immediate assessment. We did file a statement of costs yesterday, which ought to be before you.
Well, it isn't before me.
Neither before me, my lord.
I don't think it is. No. Have you got it, Mr. Iqbal?
No, sir, no, my lord, no. I was going to make a point that I haven't got it. Might I respectfully suggest that the issue of costs, both in principle and quantum, be left for the parties to make submissions in writing?
Well,
Judge, I think that's unnecessary in my respectful submission.
Well, at present, Mr. Iqbal, I can't really see any reason why you shouldn't pay the costs as a matter of principle on the basis that, I mean, it always appeared to me from the moment I first read the papers that this was a case that was not appropriate for immediate judgment because of the problems that were raised by it. So I think you will have to pay the costs of it. As to quantum, that's a different question. If you haven't seen a schedule, and I certainly haven't seen a schedule, the question is whether any issues arise. What is the claim for in terms of cost, Mr. Dillon?
Yes, it's certainly, we filed it at about 11 o'clock yesterday morning, and I believe we served it at the same time. Certainly in the course of the day yesterday, it was sent by email to the claimant's representatives. But be that as it may, it's not before either you. This total sum is 97,200 dirham.
Do you have any instructions at all, Mr. Iqbal? Presumably not. What I think I would suggest then is that I will apply pen to paper straight away to produce the judgment, and that you exchange, and you can send the schedule directly to Mr. Iqbal, and he can take instructions, and then you can each send me email submissions in relation to the figures, and if you're agreeable, I will simply make an assessment on the basis of the figures produced and the email submissions that you make during the course of the day. Does that make sense?
I'm very grateful, Judge.
Yes.
Are you happy with that, Mr. Iqbal?
My lord, I am, but with great respect, I wanted to seek an opportunity to be able to persuade your lordship not to award cost in favor of the defendants, and I wanted to avail that opportunity by way of written submissions at the same time. Might I have that permission, my lord?
Well, if you want to do it at the same time before you've seen my written judgment, you may.
I'm grateful.
But, as I say, I think you've got a very uphill struggle in the context of a case that on its face appears to me to raise all sorts of factual and difficult issues that simply aren't appropriate on summary judgment. And when you see my reasons, the point will come home to you with a degree of force, I think. But yes, you may have liberty to make such application as you think is likely to have any impact.
My lord, I'm very grateful. I should. Yeah.
Yes. Are you 3 hours? 3 hours ahead of us at this time of the year? I think you are, aren't you, Mister? Is that right?
I think we're 4 hours today.
Right. What time are you now?
It's just after 2 o'clock.
Yes, so it's 4 hours. And Mr. Iqbal, are you in Dubai or are you in London?
My lord, I'm in London.
I thought you were, yes. All right. Well, you've got a bit more time than Mr. Malone has, unless he stays up to burn the midnight oil. But can I suggest that you both try and get submissions on, and you can send an email straight away to Mr. Iqbal. You've got his email address, have you?
Yes,
with
indeed.
The schedule.
He'll make schedule, and indeed his instructions, no doubt. Yeah.
But if you can both get your submissions in, let's say by 3 o'clock London time, which gives you plenty of time from now, by which time I hope I will have more or less produced, I'm sure I will have produced a written judgment, then I can deal with the costs probably at the same time in the context of the written judgment itself.
My lord, once again with great respect, if I might ask for a bit more time, because today at 2 o'clock I have to attend another hearing remotely via video link here in London. So I would very, with reluctance, ask for not later than 10 o'clock tomorrow morning.
That's a bit of a pain, but yes, all right.
I'm very grateful, my lord.
It's just I like to get things out of the way if it's possible, but there it is. No, you must have whatever time you think you need on that.
I'm grateful, my lord.
Very good. Anything else that needs to be dealt with now? I make it quite plain that I think this matter should come back before me or another judge for case management once the Court of Appeal has decided whatever they decide. unless the parties see that that's completely inappropriate because the Court of Appeal decides something that makes that completely unnecessary, in which case you can just send emails to the court and explain why you think that, if you both think it. All right.
Very good.
Does that make sense?
I think that absolutely, and I think the parties can note that once the ruling of the Court of Appeal has been handed down, we will liaise with both of us with the registry with a view to having a date.
And you can talk to one another and see if you can reach agreement as to what you think the sensible progress of both matters is thereafter in the light of the Court of Appeal. And if there's agreement, all well and good, the court will have to approve any agreement. If there's disagreement, then the court can make a ruling. But as I say, I don't think it's a matter that should go back before the judicial officer. I think it's a matter therefore a judge ought to determine. And in all probability, it makes sense for it to be me, since I've dealt with this aspect.
Thank you very much.
Great for my lord.
Which judge dealt with CFI 24?
Justice Al-Sawalehi ruled on the applications, but there has been no there's been no real substantive outing.
Right. Okay. Well, there we are. It's always a question of who's available and so on and so forth. But
I think that yes, I think that your consideration today has been the first merits-based consideration.
Very good. All right. Well, thank you both of you for all your help. Very grateful to you.
Grateful, my lord.
You'll wait to hear from me, and I'll wait to hear from you.
Grateful, my lord. Thank you.
Thank you very much.
I think technically you have to send your emails into the registry rather than send them direct to me.
Yes.
But if the registry is happy that you should copy me in on your email to the registry, which is probably sensible, you can get them to. Well, actually, I can give you my email address now. It's probably the easiest thing.
Thank you.
It's J Cooke without any dots anywhere. J Cooke with an E at 7, the number 7, kbw.co.uk. So if you copy me in on your emails to the registry, I think that fulfills the necessary requirements. Is that okay, Meta? Are you there, Meta?
She may be
muted. That's okay. Let's assume that's okay.
Yes.
All right, very good. I shall sign off both on the phone and on the video. I'm sorry my video appearance didn't materialize second time round. I don't know why that should be, but there it is. Thank you both very much indeed.
Grateful, my lord. Thank you. Thank you, sir.
Very good.